This is Law of Contracts CCRI, Spring 2020, Monday night, Lincoln Campus, 7 to 9:30 session. We are now going into the second half of Chapter 17. There are times when, even though the contract would say there can be no assignment of rights, the one party or another may be able to assign their rights without the other original party stopping them. In contracts where the only performance on one side is to pay money, so I am going to sell you an item for $500, and we have an agreement on that. I'm supposed to make delivery in 3 weeks. I make delivery, and you are supposed to pay me $500. The only thing that you're doing is paying money. I can assign that, and very often that happens, particularly if I'm in business and I have creditors or I have some type of loan for the business. Very often I have, as part of the loan agreement with my lender, I have assigned the rights to all my receipts payable, so that if for some reason even I didn't chase you for the $500, the person I assigned the right to receive that to, my lender or some other creditor of mine, might have the right to go after you and to hunt that down. The IRS, even without an assignment, takes a position that they can, if I don't pay my taxes, they can audit my books, find out who owes me money, and they can go after the people who owe money to me and require that the payment be made directly to the IRS and not to me. So in that type of situation, where the only duty on one side is the payment of money, the right to receive that payment can be assigned, even if the agreement said no, it cannot be. It's just a part of the long-standing banking and business transaction realities that is allowed to happen. In real estate transactions, the anti-assignment clause is very often put in purchase and sales agreements. We don't want somebody entering into a contract with you to buy your house, then turning around and assigning that to a third party and making $20,000 or $30,000 that you could have made. So quite often there is a clause saying that the contract is not assignable. However, the clauses have to be very carefully worded, because there are two things that come into play here. One is there's something called restraints against alienation. The courts have long held in real estate law that you cannot create a deed to property or contract to sell property that basically says, I'll sell you this property so long as you never sell it to Fred, ever. That the whole purpose of having real estate transactions is to make property freely exchangeable, freely able to be bought and sold, freely assignable. And so therefore, that type of a restraint against alienation, trying to block a particular person from receiving the property or from receiving the benefit of the assignment, would generally held to be void and null. The same thing today, if you try to put in some kind of a restraint on or prohibition against an assignment, that could be interpreted as having a racial, religious, or ethnic connotation. In real estate transactions, the law is very clear and is very tightly enforced on both the state and federal level that you cannot discriminate according to the general categories of race, religion, national origin, sex, sexuality. There's a whole list that if you were to study equal protection law, you'd be going over in detail. And you have to, number one, you can't write an initial contract that has some type of prohibition in it like that. But you have to be very careful about even saying, I am saying you can't assign this contract, to make sure that that anti-assignment language cannot be interpreted as having some kind of regulation to stop people from selling to one of those protected classes of people. Any type of restriction on assignments that would fall into that category is null and void. It's clear at this point, based on several Supreme Court decisions, that that type of a restriction on an assignment could not be enforced. By their legal definition, certain things such as checks, promissory notes that you sign for the bank when you borrow money, and other types of what we call negotiable instruments things that deal with the exchanging of money and funds. By their very definition under the UCC, these are made to be freely assignable, and you cannot restrict them from being assigned to a third party. The whole nature of them is that they are set up in such a way to be a substitute for money, for dollar bills and $20 bills and $100 bills, which are freely assignable. And so these types of documents are. So anything written into one of them that made them, said that they could not be assigned, would do one of two things. Either the non-assignment clause would be void, or it would make the instrument itself void. It would mean that it didn't qualify to be a promissory note or a check. Under the UCC, the right to receive damages can be assigned by the injured party, and no contract clause can prevent this. So if we get into a situation where the contract is broken down and one side is suing the other for damages, that right to collect damages can be assigned to a third party. Again, 99% of the time in contracts cases, and we'll get to this in the next chapter, in chapter 19, when we talk about damages, damages in contract cases tend to be money. There are some times when the breaching party might be ordered to do what they were supposed to do, but those are rare. Normally, contract damages are reduced to money, and again, you can assign that potential judgment without any problem, and there can be no prohibition against doing that. Now, do you have to give notice of the assignment to the other original party? There is nothing in the common law or in the UCC that says that you need to do this. However, states take two different positions on what happens. Suppose we have an assignor who is a bad party. They are looking to perpetrate a fraud. So on Tuesday, they assign their contract rights in exchange for money to Mary, and then first thing Wednesday morning, they purportedly assign the same contract rights for money to Joe. We now have two assignments sitting out there. Both Mary and Joe are claiming they are supposed to get the benefit of the contract. The states have different ways of dealing with this. In one system, whoever first received their assignment, which here would be Mary, they would win in this situation, and they would have the right to obtain whatever was due from the other original party to the contract. The theory of this being that when the assignor gave all their rights up to Mary, there was nothing left. They had given their rights, Mary held the rights, that's the end of the story. Other states take the position that there's a notice aspect involved in here. So if the rights were assigned to Mary on Tuesday, then they were fraudulently attempted to be assigned again to Joe on Wednesday, and on Thursday, Joe went to the original other party and said, here, I'm here to collect the whatever is due to me under the contract, and the original party went through and performed. Because Mary got their second, in these states, they would say that Mary had lost, that it is the first one to give notice that we are now holding the rights and we intend to collect them, that is the person who would actually obtain the rights from the other original third party. So a word to the wise is that if you do ever accept, or a client ever accept rights by way of assignment, it is absolutely positively imperative that you inform the other original party as soon as possible that this is happening, so that there is no mistaken giving of the performance that's due to some other person claiming to have the assignment rights. Now, if the assignor perpetrates this type of fraud, he has basically violated a contract agreement with Joe, with the second assignee, who would have the rights to go after the assignor to get their money back. However, the reality of the world is the people trying to commit fraud usually do it in such a way that it is difficult to find them or trace them or to go back after them. They very quickly disappear with the money, and you are left there holding nothing but a worthless assignment. So again, while notice is not required under the common law, under the UCC, it is absolutely worthwhile, if you're ever in the situation yourself, or if you're dealing with clients who are receiving rights by way of assignment, that they let the original party, as soon as possible, know what they are doing. I want to go back to delegation of duties in a little bit more detail than we talked about them on the first half of this lecture. Again, a delegation of a duty is a situation where somebody has contracted to have a service performed by the other side. The law calls this performance of a service a duty. And while generally contract rights can be assigned, delegation of duties are much more limited in when they can or cannot be assigned. All right. Delegation of duties are usually prohibited when, number one, the duties are personal in nature. All right. So, again, if you're dealing with an artist, a musician, a photographer, a lawyer, a doctor, an accountant, an architect, a dentist, you can think of the whole list. The services are personal in nature. They're not something that is cookie cutter or standardized or where you can easily throw in a new lawyer just out of law school 2 months ago and have them exchange places with somebody who's been in practice for 20 years. There is a definite reality of when you're engaging somebody for a personal service contract, usually one of the things you're looking for is their skill level, their expertise level. All right. And that's part of the bargain, and the law holds it to be part of the bargain. If they substitute another person, you're not necessarily getting the bargain. Right? If the performance by a third party would significantly change the nature of the performance. So here, again, we get to talking about quality and expertise. You may feel much more comfortable having a surgeon of 20 years do your open heart surgery than having somebody who just finished their internship last month. And not to say that necessarily either one would be better or worse, but just the idea being that if you contract with one, you're looking for the skill and expertise level. All right. Certainly when it is prohibited by the contract. And if you were entering into any type of a service contract and have any say over the terms, I would say that one of the things that should be put in there is that the duties cannot be assigned to another person without your permission, without your express consent. All right. Now, I already stated that certainly doctors, lawyers, accountants, performers, photographers, artists, their duties cannot be delegated, but this can even extend to the trades. Certain carpenters, plumbers, electricians, painters, tile layers may have certain skill and expertise, and that's what you're contracting for. There are other types of personal services, however, that are pretty much interchangeable in terms of who performs them. One of the things I can think of is that you engage UPS to deliver a package for you. It's Christmas time, they're extremely busy, and they take that package and they turn it over to another carrier, or they turn it over to FedEx. Now you could complain that, I wanted UPS to deliver the package, but the delivery of packages is not something that is normally inherently tied up with the skill level of the person doing the delivery. So therefore, I would say in that type of situation, UPS probably has the right to assign that duty to somebody else. All right. Same thing would probably apply if your car broke down. You call a tow company, and the tow company says, all right, we'll come and get your car. They happen to get extremely busy, and they call one of the other tow companies in town that they deal with from time to time and say, hey, can you go pick up this person on Route 146 or Route 95 and get their car? They called it an hour ago, and we're having trouble getting to them. The nature of having your car towed does not necessarily require individual expertise or skill on the part of the person driving the tow truck in the same sense that a doctor or a lawyer or an artist would be. So these types of delegations of duty are allowable, and you probably would not win in court by claiming that you don't have to pay because the right tow truck company didn't come. All right. However, any situation where the delegation of the duty substantially affects the nature of the performance, then it is prohibited. It cannot be done without express permission from the other side. You contract with a famous television or movie star to host your award dinner. They cannot substitute somebody else to go and do that dinner for them, because the whole purpose of this agreement is to get this famous person there. It is the very nature of their personal fame and notoriety that you are trying to purchase, that you are trying to get by way of your contract, in substitution of just about anybody else, or actually probably anybody else. Even another person just as famous is not this particular person, this particular former. So in that type of situation, they could not delegate their duty to a third party. They would be required to perform and to go through with the contract. And if they refuse, then they would have breached their agreement and damages would apply. The effects of a delegation or attempted delegation of duties. First of all, if the duty is one that is not able to be delegated, the original party can refuse to accept the performance from the substituted party. So if the famous movie star doesn't tell you they're going to switch off with somebody else, and a different person shows up and says, "Hi, I'm here to be the MC for your awards dinner," you have every right to tell them, "I'm not accepting performance from you," and then the next day go to your lawyer to begin a suit against the original person in the contract. In some situations, if the person allows the delegation of duties to take place, and then the work is done poorly, or the performance is done poorly, the service provided poorly, again, just as with regular assignments, you can still go after the original party for the poor performance of their substitute. And in many situations, in many states, the courts would also allow you to sue the person who's been substituted for performing poorly, and you could go after both of them to attempt to recover whatever damages the court says you're entitled to. All right. Sometimes an assignment can comprise both an assignment and a delegation of duties. And this is a type of situation where, again, you're supposed to be paying somebody, you haven't made payment in advance, you're paying them for duties. They assign the delegation of duties to a third party. They also assign the right of payment to that third party. So there are some situations where we're dealing with both assignment of just regular contract rights and delegation of duty rights. All right, I think I will stop here. It looks like we have enough to go on here to a section 3. So I will see you again in section 3.